My name is Alexander Siegel. I'm an immigration attorney in New York City, and we're going to talk today about replying to the RFEs and RFEs extensions. So I get a lot of messages from people that they have missed replies to the request for additional evidence or notices of intent to deny from the USCIS. Requests for additional evidence are usually questions, request inquiries about evidence on evidentiary issues needed to decide the case, usually sent by USCIS from time to time when they cannot decide the case or are unsure they can decide the case on the record presented. They usually come on the USCIS Form 797C, and they require certain attention. They give very specific deadline, and if you fail to answer the RFE within a deadline without special request and grace on the part of USCIS, usually those late filed RFEs are not accepted. If they're not accepted, the case is going to be decided on the record presented before the RFE was issued, and that's usually not a good sign because it didn't overcome the very reason why the RFE was sent by USCIS. Notice of intent to deny is a little bit different type of an inquiry. A notice of intent to deny usually is an advance notice to you by USCIS, by the government, that they are about to deny your application unless you come up with certain ways to overcome their concerns. Usually those concerns are pretty grave, and you have to do a lot of work to overcome them. It also needs to be done in a timely manner, because if you do not reply within the time allotted, then in this case the case is going to be denied, because they already told you they're going to deny it unless you come up with evidence which you fail to present in a proper and timely manner. So for this reason, and responding to the COVID-19 related shutdowns, USCIS has come up with ways to address this potential problem that many people have when they are having difficulties obtaining evidence, because many people are afraid to give evidence because they are afraid to go out of their apartments and houses, and also because many services that could be involved, like police and other government services, are less accessible than they should be, or as simple a service as the marriage license bureau can be closed. So for this reason, the government came up with an idea which they implemented in a policy statement on their website, that they will give additional 60 days extension to people who received their RFEs and requests for additional evidence or notices of intent to deny between March 1st and May 1st. So for this reason, they would add 60 days to the date on the notice, to the date on the notice of to the expiration day on the notice of intent to deny or request for additional evidence. Where do you find the expiration notice? You have to look at the very request for additional evidence form or letter, and it usually states on the first page or on the last page, or somewhere in between, when the government expects to get your reply back. They can give you for as much as 87 days, or for as little as 30 days. So you have to be careful. So it is to the last day on that expiration period for replying to request for additional evidence or notice of intent to deny that the 60 days are added. Now, make sure that if you are trying to utilize the 60 days, that your RFE or request for additional evidence was actually received between March 1st and May 1st. This is very important to remember, because if they were not received, the 60 days additional time period does not apply. This deadline usually is a good news for you. In recent years, we have paid attention that USCIS is looking for every reason to deny your application. They oftentimes deny applications on trivial demands or on reasons which make very little sense. So, or just not commonsensical at all, or counterintuitive. So for this reason, it's very good news for those who are getting extra 60 days, so they can concentrate on thinking through the response, obtaining evidence, and making sure the response is received fully documented. This is why it's so important not to engage in self-practice and instead reach out to an immigration lawyer to seek assistance and replying to requests for additional evidence or notice of intent to deny. Doing so on your own without the proper legal representation can have adverse consequences that I'm sure everybody who is replying to request for evidence or notice of intent to deny is trying to avoid. We recommend that you send the reply anyway as soon as practicable, and if your delays were somehow related to the COVID-19 shutdowns, explain the COVID-19 shutdowns. Actually, that advice also applies to people who received their RFEs outside of the March 1st to May 1st period. For example, if they got it in June or in May, and still, because of the COVID-19 closures, couldn't reply on time, it's still recommended that you send the reply as soon as possible, and that you include a cover letter where you explain the reasons why the delay was connected to COVID-19, if it was connected to COVID-19 shutdowns. Okay, if you know that the government issued a request for additional evidence or notice of intent to deny, that two things can happen. First, you received it late after the deadline, or somehow got a hold of it late. If, for example, you forgot to change your address and eventually a person from a previous address delivered those to you, or you found your way to USCIS website and checked your case number. In any event, it's a good idea periodically to check your case status, and you do that by using the case number that you can find on the original Notice I-797 USCIS receipt that you received when your case is accepted for processing. You can also find it on the backside of your check that you used for fee. You can request that from the bank and use that number to check your status on the USCIS website. Those status notices are not always current. Actually, for the most part, they are leaving, to wish for better in terms of keeping current, but at least it's a starting point for you to check the status of your case, and maybe you will see that the request for evidence was issued, or notice of intent to deny was mailed to you, or some kind of a correspondence was mailed to you, and alert you that you didn't get it. So you can contact USCIS and see whether they can send you another copy. So we recommend that you hire an attorney to reply to a request to deny or notice of intent to deny. Usually, those things are good wake-up calls that maybe it is time for you to engage professional legal representation, because this is your last line of defense, and you want to do the best job possible in trying to defend your application and have it, or petition and have it approved. If you need legal representation, you can find my information in the links below. I'll be happy to talk to you, and good day.